While we are waiting for the other colleagues, I think there's still 2 to come now. No, it's not 9, I know. I say while we are waiting for the other colleagues, I'm going to try and do the following. That we finish before 1. And then you can take the lunch, and afterwards you can go to the High Court. Do me a favor. None of you are excused from attending the proceedings at 3:15. And none of you will be excused from attending tomorrow's residual court. I've made a copy of something that I will save. Let me say this: I will save a particular person an embarrassment tomorrow morning by reviewing something that served before tomorrow morning, but I am going to remove it from the roll for a multitude of reasons. But what I did in that particular case, I've printed out a return of service, a particulars of claim, and the annexures. I will hand it to you shortly. And then I'm going to give you a few minutes to review it and tell me what you should have done in this matter. We are now 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Someone is missing still? Okay. But let's just carry on. You could see yesterday what I do not do in my presentations. I am not printing over and copying over. You have detected from my presentations, I'm not printing over and making more paperwork and more things for you to look at. The substance is in the rules. The substance are in the practice directives. I will give you 2 cases this morning that I want you to read. Both of the cases form part of, I think, the 108 notes from the registrar to the practitioners that I gave you. Especially the one judgment, the Futeni judgment, is a beautiful judgment concerning a primary home. Tomorrow, if I remember, and I hope I do, there's another Supreme Court judgment that I want to give to you concerning service and the purpose of service. And that you can also then read with rules 8, 9, take regard to 10, 11 also, the other forms of service. But if you read that judgment, you will see that there was a point taking concerning the form of service. But fact of the matter is that if someone receives service, even if it's defective, and they enter an appearance to defend, it's fine. Then it's spurious for anyone afterwards to come and contend that the service was wrong, because it was received and there was a notice of intention to defend entered. So, and that is the main purpose basically. It's said in beautiful words by the Supreme Court, but that is the purpose of service. Someone must bear knowledge. Before we go to the text of Rule 8, say, for instance, one of the rules are cited by the Deputy Sheriff. There's an address in the particulars of claim that might differ from the address in the return of service, but personal service was effected. Not necessary to look at any niceties any further. It's a time waste. If you have personal service, it could have been at Noordoever, but your address is in Oshakati. But if a deputy sheriff took the opportunity that they are mostly availed, either in the particulars of claim or in their instruction letter, from the attorneys with telephone numbers on it, and the deputy sheriff phoned that numbers, and he realized that Mr. Max is not in Oshakati at the moment, he's at Noordoever, and it's sent to the deputy sheriff from the south, and there's personal service. Then there's personal service, and the end of it. All the other things then doesn't matter. Bring me to the point that personal service, when it's a natural person, is preferred. It is the best way of service. All the other shenanigans in the rules are therefore when it is not reasonably possible. Let's look at Rule 8. If we look at Rule 8 to A, from there, in any event, it is clear that what I've said, personal service is the first preferred matter. But now, 8 to B say the following. Where personal service is not reasonably possible, and that is where you are going to apply a value judgment on any service on a natural person that you receive on your file. Then it say that basically if we go through that whole rule, a person over the age of 16 must be a responsible person, etc. And then there can be service in terms of 8 to B. They use a lot of words, but if you cannot see from the return of service that there was a reasonable endeavor to get hold of the litigant, you don't have to give validation to that return of service. Let's go practical. A deputy sheriff, also officer of the court, they have a lot of work. It's not an excuse, it's a fact. They have a lot of work. So they tend to make their work as easy as possible. They cannot effect personal service. They never use the words. There's one deputy that I will exclude here. Someone in the north, they do it sometimes. They never say in their returns of service that personal service was not reasonably possible. They never say that. And then if you go through the return of service and you do not find failed attempts, 1 or 2, or an attempt to phone, or something extra, you are entitled to ask for service to be effected again. And that a deputy sheriff should certify why personal service was not reasonably possible. Because for a natural person, we prefer personal service, unless the natural person also have elected a domicilium citandi. But in any event, personal service is the safest. 8.2b, read through that services with the investigative mind. If in your mind there was reasonable efforts to get hold of the defendant, give effect to the service. If in your mind there was not reasonable endeavors to effect personal service, ask them to take a further measure or to serve again. If we look at Rule 8 2C, when in the particulars of claim, there's an allegation in paragraph 2 or paragraph 3 concerning the defendant that say and state his place of employment or a place of employment. Then, if it is an employment address, we quickly glanced through it yesterday, it must be served, if not on him personally, if he cannot be found there, on someone that has authority, apparently authority over him or her. (8)2D sometimes pose a problem because here the discretion of judges and how they read the rule and magistrates, any judicial officer will differ. Strictly speaking, if a domicilium was chosen, one can leave the process, as indicated there, at the domicilium. But never forget Rule 8.4, 8 sub 4 then. It's preferable that 8.4 be blended with 8.2D. But then there must be a certification that no one was willing to. No one was willing to, yes? You must still apply. Ms. Savage, I know, but still, and that is why we must look at the rules holistically. You must still, as judicial officer, be satisfied of the effectiveness of the service. But that is not effective, to put it at a flat rock. I will say, underlying to that, it must be visible. It must be visible. You cannot go and hide it under something. Normally the public will not have access to that place. But that is the last form of service, that you just leave it at a place where the public have access when you have a specific name of a defendant. And then you must investigate the papers in front of you. And we go back about 7 minutes from now on. Was there a telephone number? Did the deputy sheriff at least mention that there was 1 or 2 failed attempts and what they have done? Did he phone? Did he try to get hold of someone? Let's go back to the example of Marua Mall yesterday. We have in the particulars of claim but it's more to do now with 8.3. We have in the particulars of claim, but let's stay at the natural person. If you apply 8.4, where the public has access to the document, say the address of employment was Marua mall, block C, third floor, blah, blah. Then, if you then leave it at a place like to a door, or on a table in the hall if you cannot find anyone, but in the open, then the public will have access to it. But you will very seldom find any, I never until now saw any return of service where the deputy sheriff have said where the public has access. They also don't use it because there's something, there's 2 or 3 specific requirements, and then obviously you will not leave it at the ground floor of block C because the public has access to the place as near as possible to the address of service at least. But you will seldom find such an example. If you find it and you are from the particulars of claim and from the return of service, you are satisfied that there were no other opportunity for the deputy sheriff for service, then you might accept a certificate saying that he left it at the place where the public has access. If we return to the domicilium setandi, I just want to make the point again that A2D when we look at 8.2D, we will never forget what 8.4 say, because it's a further qualification. And they never forgot the place where I started yesterday. I started at 9 sub 4. You must be satisfied. And then 8.2E, service by delivering a copy thereof to any agent who is duly authorized in writing to accept service on behalf of a person. But then a deputy sheriff must certify. He will also certify that he has seen. It does not help if someone tells you, I do have authority to accept service in writing. At least the deputy sheriff must see it. It must be shown to him. This is also a matter of service that seldom will come before you. I was a lucky one that in a certain set of facts that I had to assess service in a case that is case managed by me, and where after 18 months suddenly it became a point in limine that the person who received service did not show his authority to receive service, and the deputy sheriff has never certified in terms of 8.2D that that person or that agent, in this case it was an attorney, had written authority to receive service. And because of that was not done, months down the line, when a certain problem has arisen, now it's suddenly a point in limine. That is what brought me to research and get to that one Supreme Court judgment concerning the purpose of service. You cannot accept service, act on service, have a notice of intention to defend filed, go through various court processes, And when you are pushed in a corner, you now come with the point of invalid service. That is not on. I don't want to say too much because on certain other points, judgment still is outstanding on that matter that I must deliver. But we all know as reasonable people that it's unheard of to let a matter go for so long and then take a point. Now, I want to have feedback from you, ladies and gentlemen. I went now through 8.2. Do you think it is necessary that we go to 8.3 and further? You have the essence. You have the essence now of service. And the further requirements are prescribed by the rules. But obviously, the party had knowledge. The party had knowledge. The party reacted. The party reacted. That is where we must sometimes apply our minds holistically on a matter. I say holistically. I like the term, take a bird's eye view of any matter. Get some distance, look at all the facts surrounding, and make your judgment. Make your judgment. The purpose of service is that the litigant should bear knowledge of the litigation. In this matter, you say the deputy sheriff was not involved, but one of the litigants or the litigant got knowledge and he reacted thereto. That is why the service is so important, and that is why the deputy sheriff's involvement is so important, and that is why Rule 8 will always be there, because of the following circumstances. Say there's no response from the defendant. One should deduct that probably the defendant do not bear knowledge without any process in terms of Rule 8. In that case, in the example you have mentioned now, there was a response. But in the same case, and I don't know the facts of the case, in the same type of case, say the matter became then in front of a judge on default proceedings. There's no service. There's no defense. That's why it's on default. What do you do with such a matter? You struck it from the roll. You struck it from the roll. That's why Rule 8 is there. But if Rule 8 is not complied with, and the litigant know of the proceedings, and enter a notice to defend or a notice to oppose, it's fine. Then the matter can carry on. You understand, that is an exception. That is an exception. But it cannot be applied when there's no reaction from the litigant. Then you must look whether there was compliance with service. I'm now going to, and please, maybe I must ask you to return the papers to me after this meeting, because the case is still running. I did not make an order on this case. I did not delete names, because one of the plaintiff is a corporation. And you will not hear anything about this tomorrow. I will remove it before the time. But I want you to look at this paper and to critically question the service as well as the remainder of the papers. Let me quickly discuss it. Let's take a short break, it's all right? Let's take a short break. Let's make it 10 minutes. Come and get the papers here. Read through the papers, walk around, discuss it with each other if you want to. After 10 minutes, we will quickly discuss that. For the moment, let's skip the return of service in front. You have read through the particulars of claim and you have looked at Annexure B. My question to you is, does it matter that Annexure B was not signed by the purchaser? Sir? I want an answer from you, please. What's your surname again? No? Velikosi. Velikosi. Mr. Velikosi. Does it matter that Annexure B is not signed?
Yes, it should.
Okay, tell me why do you say so? That is the terms and conditions of the sale.
Yes.
Okay? One would have liked it to be signed. I concur with you. But say we look at Annexure C and accept that it is the purchaser's signature thereon. Let's accept that. Does it, if you read Annexure C together with Annexure B, does it still matter a lot that Annexure B is not signed?
In my view, it should actually matter.
Okay, and if you look at Annexure A and C and the fact that B is not signed, does it change the picture or not? I hear what you say, but let's go to the type of transaction. It's an auction. Look at the particulars of claim. There's a particular averment that the terms and conditions of the auction sale was read out by the auctioneer, not so? Before the auction, it was read out. There's an allegation saying that the terms and conditions are generally displayed for all the bidders to see the terms and conditions. That is two crucial allegations in the particulars of claim. And then if you go to Annexure C, the bottom part of Annexure C where there was a signature appended by the defendant. And remember this subscriptor caveat, we will quickly come back to that adagium in maybe after tea. But he signed that he have read it. He signed that he be in knowledge of it. All what the plaintiff then did is to have the unsigned Annexure B, preferably it should have been signed to have no doubt at all, but it's not. But there is a signature saying, I have read it by the defendant. I bear knowledge of it. So, in this particular matter, I, for instance, will not remove the matter because Annexure B was not signed. Because in the papers in front of me, again, taking a bird's eye view, all the necessary allegations are there. The terms of the agreement was acknowledged and signed, although in C, the acknowledgement thereof. And then you will see in all the reading that you can do concerning auctions and public auctions. Auctions, by the very nature of it, and the bidding one will find a lot of times in auctions that certain documents are not signed. But if the key elements for an auction is satisfied, that the bidder's attention were drawn, terms and conditions were read out. I don't know whether they lie or not, but I attended a lot of auctions where it is done. If I say I attended a lot of auctions, I just want to rectify they're not ordinary auctions, specifically livestock auctions. I know what the auctioneers do on that auctions. And if they say there, they have read it, it's displayed, that is my experience too. They read it, it's explained. And if the bidder then sign a paper that say, I bear knowledge of the terms and conditions, it's fine. But there's still other problems. You have a question, Ms. Mkumela. Paragraph 6 say the defendant duly signed an exercise and took possession of the goods. And then if you look at C, you find there for what he signed. That satisfied me that he bear knowledge. But there's something else that if one look at the prayers of the particulars of claim, if we look at 1, an order directing the defendant to return the goods as described in Annexure C to the plaintiff forthwith, and failing compliance therewith, authorizing and directing the deputy sheriff to take the said goods in his possession and deliver same to the plaintiff. This is a spurious prayer. If one looks at the contents of the particulars of claim and the contents of Annexure C, how after this auction happened in 2015, not so? How after 2 years will, if the plaintiff did not go through the necessary requirements to identify the livestock correctly, which was sold on the auction, how after 2 years will anyone recognize that lean cows and heifers, etc.? If you look at Annexure C, there is no description concerning the marks, say on the ears, the ear marks. There's no description at all. So the goods 2 years down the line is unidentifiable. But from practical experience, and that will be of interest to most of the men in this room, but maybe to some of the ladies too, practical experience say that the instructions obtained from the plaintiff was not full and complete. And then the legal practitioner obtaining the instructions might have not known that one question to the auctioneer would have identified the cattle to validate prayer 1. And that would have been, okay, guys, you were the auctioneers. You sold the cattle. You are required by 2 or 3 acts to identify cattle that is sold on your premises. You are required to have a state veterinarian present at an auction. You are required to see there to that state veterinarian give movement permits to the buyers, identifying the cattle. But if you don't know that, because you are only a lawyer, You will not ask it. But it's still fine. Because you as lawyer and the legal practitioner, at the end of the day, act on the instructions given by the plaintiff. And if the plaintiff, in this instance, did not bother to give full instructions, they will bear the consequence that the goods will not be returned to them. That no deputy sheriff will be able to attach identifiable livestock. So that prayer become moot. That in any event become moot. The offspring, if they get the goods back, they ask for the offspring, they can do it, yes. The offspring will be instead of interest, which you will have on the second part of the claim. The money plus interest. Because offspring obviously will be the interest. There's a progeny. Now, I can tell you from practical experience in livestock, especially in cattle. If I go to the vet offices today and ask them to search their records, give them the auction, the place of the auction, then I ask them, I want all the movement permits from the place of auction to their destination. The farm is mentioned here. It must be there, and it will be there, and that movement permits will give you the ear tags. It will give you the ear tags. The moment you have the ear tags from the initial cattle, as the processes of registration work, required by the veterinarian officers and by the meat board, you will be able to identify even the offspring and to whom it's sold afterwards. You must, just for interesting sake, you must remember that it's not so difficult anymore to trace animals.
So after 2 years, those ear tags will still be there?
Yes, if they are not slaughtered. Yes, Ms. Savage?
I'm saying for brand now.
Yeah. All of you saw cattle in the last 2-3 years. The ears are full of ear tags. That is requirements. And it go for our meat exports to Europe. If, when the cattle is slaughtered, there is no certificates concerning earmarks and injections, etc. The moment if the cattle cannot be backtraced to their origin, the meat of that carcass is not able to be transported or exported out of the country. There's very strict requirements concerning cattle. If you want to sell live animals on other auctions or outside the country, it must be traceable to their place of origin. And it is all of that is possible. Otherwise, if you breed cattle on your farm, don't register them, don't ear tag and earmark them. Your neighbor come and steal some of your cattle, you will not have proof of which one of those cattle were your cow. You will have difficulty in criminal courts. You can only use that meat if you do not follow the requirements of registration and the animal health related acts and the vet acts. You will only be able to breed for own consumption. But you will still be liable under other acts because you should have registered. So what I'm saying is that's a livestock auction. if the auctioneer, the plaintiff in this case, if they are serious about getting their money back, they should give full instructions, it's possible. Then they could have gotten the cattle back and the offspring back. But now they didn't. And the legal practitioner taking the instructions might not have the type of farming or livestock experience to ask them the question. But it's not his or her duty. It's the plaintiff's duty to supply the particulars. But if there was an understanding in the beginning of the transaction and when the instructions was given, there would have been a simple question. The auctioneer would have supplied papers and the whole matter would have looked different at the end of the day. What happened in this matter until now? Summons was issued sometimes in February this year. Particulars of Claim 2. There is no changes, no amendments. Let's go to the particulars of claim, paragraph 2, and now the return of service. They will say, because of this, B, I think there's a 30 days clause there. I'm under correction, but I think it's in the terms of conditions. That payment must be effected within 30 days. Within 30 days. That is why they get that date. Yeah. Look at the return of service. Okay, you will remember also from our studies that letters of demand, that is important to place someone in Mora, unless the contract or the terms put someone automatically in Mora. That 30-day clause puts someone. Okay, let's look at the return of service. Mr. Sir, I forgot your name since yesterday. Prior 2 of the particulars of claim and the return of service. What do you see? Is there anything else in all those papers that tell you that the address where the deputy then, in the end of the day, served, that he got that address from anywhere else in the papers? No. What happened in this matter, I can give you a bit of background. Because of the, and I must be careful, because of the lack of care by the auctioneer, Annexure A was not completed fully. Annexure A was not completed fully. And that happened at a lot of auctions. You go there, you must register as a buyer. You fill in a form like that. The secretary sitting there, that is not the auctioneer. They think if you give a cell number and particulars like that, it's enough, there's something. Especially when they know the face of the buyer. He frequented auctions. But that is not the problem of the legal practitioner. It's not the problem of the person taking instructions. It's the problem of the plaintiff. There was specifically questions asked like the number, an AGRA number. Now, you give an AGRA number also if you are a regular client. I said the auctioneer's name now. At some time, they give you a number. Whether you have an account with them or not, you get a member number. If instead of, if there's no AGRA or no number, it is really a lack of care that the stock brand or fan meat number was of this specific buyer, the buyer now, not the cattle that he's going to buy, but the buyer. You have a registered brand. you must take that, because then you can identify, you can trace where you move permits with a movement permit, but that's not there. And because that is not there, there's a farm. Now, one should accept that the farm process, for lack of knowledge, we must accept that the farm process was the farm to which the cattle bought at the auction was afterwards taken. We want to accept that, but can we? Because we don't have the movement permit. It can just be a name that someone gives there. And then to give a PO box number on a paper like this, it is, and the auctioneer accept it, that's purely a lack of care. And then a plaintiff cannot complain if he cannot get back his goods, livestock, maybe even money, even if the matter is undefended. A good point concerning the service. The history of this matter is that it was early in the year issued, and then the sheriff could not find the guy. They could not find the guy. Tracing agents were appointed, blah, blah, until they got this last address where service was done. But by that time, the summons already lapsed. By that time, and that you will not see here, by that time, the matter was already referred to case management in terms of Rule 1322. 132, it's a lapsed case. Then automatically it's referred to a managing judge that must deal with that case in terms of Rule 132. That is not on the papers before you. But that is the background of this matter. But regardless of that referral then, the legal practitioners went to the managing judge and told the managing judge, no, but we have traced this guy now, and the matter is on Judge Oosthuizen's residual court role. That was a previous one already. Please refer the matter to him. When a case is referred to case management, the case management judge deal with it, even in default. That is one issue, a further issue that you will not see there. But the bells ring because where did the deputy sheriff get that address? If the 6 months period is becoming nearer, after you know your summons was issued, it is the duty of the legal practitioner in terms of Rule 132 to make an affidavit, not a status report, to make an affidavit why they want a further validation of 6 months or 1 year on the processes. If it's not done, it's not done. But there was an explanation concerning tracing, but it was not under oath. The matter is now on a default role. It should be before the managing judge that was allocated the matter in terms of 132. If all that, after saying all that, even if it was referred to a case management judge and I get it in as a default judge on my role, and I could have seen that after the last tracing report, there was an amendment brought about by the registrar on the summons and on the particulars of claim, with a signature or initials, changing the residential address. It could have altered the position. Although, there I must tell you, I, for instance, can become very finicky about matters like that. If something like that changed after such a long period, obviously want the process to be served again. But in this matter, it was not served again, it was served originally. But it was originally served after the lapsing of the 6 months. This, to me, is an inactive matter. There should be proper procedures. But there's no proper procedures. It's now before me on default. Because of service being effected in August, if it was personal service in August, let me tell you, if in August of this year there was personal service on Mr. K, I would have, regardless of all other things, gave judgment in terms, the monetary judgment for the 94,000. Because then he had service in front of them. Although there was a lapsing. That can be for argument. You will ask me, why can I condone a serious thing like lapsing? Look, even if the process was issued early in the year, but there's service of all the relevant papers, the summons, particulars, annexures. The guy receiving it, receive it on the day he received it in August. If it was him personally, then he would have known there's proceedings against me. He would have borne knowledge. But now what happened here? There's no personal service. There was service on an address unknown to us where it come from, this address. It was not personal service. So I cannot condone that. Because how do I know that, how should I know from this papers that it's really the residential address? I can see nothing further from the deputy. If he couldn't effect services at previous addresses, there's nothing about it here. And those returns are not uploaded on my system. I cannot even go into that history. But there's something else on the return of service. Who picked that up? The rule. The rule is wrong. Now you will tell me, but Judge, we remember what you said yesterday and the bird's eye view, etc. But now why would you not condone the rule? I would have condoned the rule if there was personal service. But I cannot now. I cannot now. And that is our modern age of computers, pro forma documents, re-generation, cutting and pasting. That is why this mistake is made. Because it's obvious. It was not served in terms of that rule. But is it really my problem? Should I break my head about that? Should you? No. We are not the litigants. Who get this return of service back to check before they certify in Annexure A the papers are in order? Who get this back? The legal practitioner. And then they certify on Annexure A the papers are in order. And they might even come to court and raise and say, Judge, the papers are in order. Because they don't go through the papers. We are not in the business, I told it to someone outside, we are not in the business of bird keepers and tending to parrots. We are not in that business. We are judicial officers, and the people appearing in front of us also don't expect from them to be parrots. Because if they behave like this and raise and say, the papers are in order, it's a phrase that they learned but they did not investigate the paper. So it's not your problem, it's their problem. Remove the matter again. They will complain afterwards, but it's costing our clients money. You are costing your clients money. Sir, lady. And your client costing himself money because of his lack of care. It's not my problem. Come back if there was personal service and they come and ask for condonation of something that was wrong on the rule in the light of personal service, fine, they get condonation, and if their papers are in order, they get judgment. They get their default judgment. But this, one can never give. Even if there's status reports uploaded of 3 pages long, you cannot give it. It's not our duty all the time, and that's what I tell legal practitioners a lot of times when they come and complain with me. But Judge, you could have that. I could have appeared and told you this. I said, is it on the papers? No, it's not on the papers. It's not my problem, it's your problem. If your practice are too busy, if you give your code words to your secretary to check, or in dereliction of your duties, ask your legal researchers to approve and endorse orders that you never saw, that is totally unethical and unacceptable. If an attorney gives his codes of authorization to his secretary and want to complain afterwards because it was not correctly done, they should not. They should take the blame, therefore. And you will have experienced, as judicial officers, time and time again, in your experience, that sometimes a lawyer raise in front of you and try to blame someone else. My associate, my clerk, my secretary. Chase them out of your court. They are responsible. Anything else on this matter? Was this a good learning example? Would you like it if, from my part, concerning now residual court matters and Rule 108 matters, how do you feel you will be better tested? With questions like we ask from school children and maybe students on university, what does Rule 8C2 say? Or should I not and should you not prefer, or would you not prefer that I compile a type of small dossier for you and ask you, and you will get the indication on the points. Go through the papers critically and give an answer on this, this, and this, and this, and this. Or just comment. Or write me a piece on this. Most of you were busy doing that when I give this out. Looking for the mistakes, writing down, and I could see some of you have tried to motivate it. That is the type of question that I think in our circumstances would be a practical question to ask and a practical way to answer. But then another caution, a friendly caution. Some things, or most of the things in law, a lot of the things there's a right and a wrong. But you could have experienced by now that I ask you to look at matters with a bird's eye view. Even if you give a wrong answer with a reasonable motivation, it will count for points. So it's an answer and a motivation. Critically assess the papers in front of you, whether the processes were followed or not. Your opinion and why is it your opinion? I will discuss it with the JP. I think he will, I'm sure he will concur with me. That will not be an easy question. I think that in default matters and the 108 matters, we should give you a practical test, and that is the near to it as we can come to practical if I give you papers to criticize. Anything else from this particular case example that I gave you that you want to discuss? I think you would. Look, if I give you the papers.
Say for instance.
No, I know what you say. Tomorrow, I am not going to address you in court.
Yes.
I will basically ignore you in court. I want you there. I will be clear in the questions I ask from the legal practitioners. You will follow what I'm doing. Because if I'm going to ask a question, I will read a part and ask for the counsel, what do you say about this? Or what do you say about this? But this particular matter, because I use it now in our cause, you will understand that I don't want to embarrass anyone to call this matter. Because I, for instance, know one of two persons that will appear in this matter, and they are not responsible for the papers. They are juniors at the particular firm, but they are sent to the court. So this matter I will remove today from the roll. It will not be called tomorrow. I will deal with it today. I don't want to embarrass people. Do I answer your question?
Yes.
Not really.
No, that's fine. That's fine.
Look, if you are tested, I know what I will try and get right tomorrow is that you have a learning experience. You must see how it's done in court. A case is called. I might even, before the time, warn 2 or 3 of the legal practitioners. I am going to be pedantic with my questions and my reference to papers. They don't know me as like that in a residual court. Most of the time, in the last few months, if I call one residual matter, it is something. I deal with it all before the time, even the part that I remain. And if I cannot deal with it, I phone them before the time and ask them the questions. Or call them to my office, because we don't have time. I don't have time, if it's not at an administrative break, to have a long residual court. I don't have that time. So I deal with the matters before. But tomorrow, already they sense there's something different, because when they phoned my office since yesterday afternoon, am I going to complete the role before it was said no? They will know by tomorrow morning early which cases are being called. Then there's one attorney which I already want. And also of your presence. I must do that, I must be fair to them too. You will find as presiding judicial officers, that sometimes you ask a question in court. The devil is still sitting on my ear. Maybe I will do it tomorrow. but I must think careful. Someone arrives in a court like this, and then when they come to the front, when they stand before they say the papers are in orders, I will ask the question, are you really going to submit that the papers are in order? And then you must see the reaction. Judge, except for this, and this, maybe we should remove the matter from the roll. Before they commit themselves, you ask them. And I did it regularly in the past. So it's amazing how someone reacts if you do not allow them to raise and say the accepted verse, the parrot. You don't allow them to go so far. You ask them before, are you really going to submit that the papers are in order? And then you get different reactions. The one I told you about, there's one beautiful girl in my court sometimes. She would just stand up and say, no, I ask for the matter to be removed. And then I thought, okay, so they came with the idea to remove the matter. But then afterwards, and I like this lady. She learned a lot as a youngster from the beginning of last year. Then afterwards, she will come to my office and see whether she can see me. She says, why did I remove the matter from the road? No, you must know. There's maybe one bit, but just please tell me, why? Why was it not ready? Then, do you have the papers? Do you have a printout of the papers? Yes. Quickly sit. Let's go through. Oh, I understand. And remember, Lady X, your duties. Look, before we break for tea, before I was appointed as judge, one of the requests, I would have done it, but I also appreciate it from our Chief Justice. One of the requests in my last meeting with them, before I was appointed, he told me the following, and we must remember that because it's missing in our legal fraternity. He asked me, Herman, please, I know you will be appointed as a judge. I know there's a lot of judges that say they are not appointed as teachers. But in our courts, we sit with a lot of young practitioners, and whom are attached to various firms, small firms or big name firms. But the inherent problem in our society is that a lot of the firms are there to make money. The principals cannot give the attention to the juniors they are supposed to anymore. The juniors are left to be taught by some secretaries 10 years in practice. Please, at the side or in court, don't be abusive of the legal practitioners, especially not the young legal practitioners. Help us train them. I appreciated that a lot, coming from our Chief Justice, and I do that. And I must tell you, I will not, but I can identify 5 youngsters that started to appear in front of me. And then in my private mind, I thought, without derogating them, knowing how it's going in practice, because I was also in practice, although as an advocate, they are clueless. They are clueless. You will have to spend time with them. in the beginning of my tenure, and at that stage we did not have co-judges to help lessen the burden of the role. There were also a lot of paper files. That there was sometimes a day and a half that I sat with a roll of 135. But keeping the request in mind, sifting in the beginning, how should I do what? And then it quickly boiled down to where I know these youngsters will appear, I reschedule that for the day after the main day. Then I go to court, then I have 3 or all 5 of them in front of me. And the one firm's files were called, which files which were not correct. The matters must be addressed further. The other matters with no problem, that's granted in chambers. And then you call a file. Then they raise. And then the agreement between us were, don't submit that the papers are in order. Raise and we discuss the case. After about 4 or 5 times, I must tell you, none of that 5. None of that 5 ever has left me with the impression after a few months that they didn't learn something. All 5 of them excelled. And when they do not know something, and it's in a default setting where there is no other party, they know my door is open. If a thing is removed, they can come and discuss it, and we go through the papers. So, when you become a judge, or even if you are a judicial officer in the lower courts, remember this. It's not your work to train anyone, but it's humane, it's legal, it is an example of what we say, to give that attention. Because at the end of the day, the judiciary want to be seen as effective. Let's go and drink tea.